Welcome back. This is Newsfile, and here is Samson's take. And today on my take, actually, my plan was to share some bits of insights with you on this book, the Ajete Anan, A Story of Faith, Imperfection, and Resilience. I had placed my order from the Book Nook store before the launch, and once it got delivered, I started enjoying it in the same manner as I did with the I Am Not Yvonne Nelson. But this morning, I'll just urge you to get your copy, just the same way you got Yvonne Nelson's. Get your copy. Ajete Anan shares very compelling stories, lessons for particularly the young ones coming up, to know the pitfalls and to avoid them. So it's Ajete Anan, A Story of Faith, Imperfection, and Resilience. It's a compelling read, I tell you. Right, but I decided, for a compelling reason, to talk to you, or to share with you, rather, about the sacked PPA Boss's corruption story. And actually, that's how I have titled it, The Sacked PPA Boss Corruption Story. You remember the story about Ejenim Boateng Ejay, correct? In 2019, in August, Manasseh Azori-Awene did an investigative story and produced a documentary titled Contracts for Sale. And it was found, among others, that a lot had gone wrong. Well, among others, the allegations against the man were that he had set up, right after assuming office, he had set up these companies. So there was this Talent Discovery Limited, TDL, a company established by Ejenim Boateng Ejay in June 2017, a few months after he was appointed CEO of the PPA. That company was awarded contracts from ministries, departments, and agencies through single source, that is restricted tendering. Again, he was found to be a majority shareholder, 60%, and director of that company, with his brother-in-law, Francis Ahen, owning 40% of the shares. It was found that the TDL sells the contracts awarded to it by the MDAs and other public procurement entities. Suppliers and contractors interested in buying those contracts from the TDL had to register with the TDL by paying a non-refundable fee of $5,000. The TDL uses links at the top to win the contracts. Then he was also found to use information he acquires in his privileged position as a CEO of the PPA, as a public procurement authority, to the advantage of this company he had set up just a few months after he got the job. And again, that his role as CEO of the PPA and shareholder and director of the TDL and other companies placed him in a conflict of interest situation. So Shraj went into the matter because the president, through his executive secretary, Nana Bedietio, had first of all interdicted him, but subsequently he was sacked, as you remember. And then they forwarded a complaint to Shraj. Shraj sat on the matter and came to the conclusion that he was guilty, and so found him as such. There was also another complaint filed by the Ghana Integrity Initiative. Shraj again found in a similar fashion that he was guilty of all that he had been accused of, and in fact went into his bank accounts. And as we understood at the time, this was a man whose private bank account held only about 40,000 Ghana cedis at the time of his appointment. But by the time that Manasseh had done this investigation and he was found, he had made in excess of 45 million Ghana cedis in the 3 years using his office as chief executive of the Public Procurement Authority. So that was the estimate if you put all the monies that the Shroud together with the Office of Special Prosecutor had found. So he embarked on, if you like, a crusade through the courts to say that certain things were done wrong during Shraj's processes and that he was not giving a fair hearing. More importantly, that Shraj, first he argued that there was no complainant in the president's petition. And Shraj found that there was a complainant. It was the president. He did it through Nana Asante too. And that Shraj had called certain witnesses, about 17 or so of them, and that he was not giving the opportunity to cross-examine them. Therefore, his rights has been breached. So the court should throw away what Shraj had done. Now, as you are aware, this week, there's a judgment of the court that is circulating, and that judgment clearly shows you that there is a judgment dated the 8th of June 2023 before Her Ladyship Justice Audrey Kokovite in the general jurisdiction of the High Court. And that judgment found that, I'll just read the concluding portion here, and then I'll make a quick, inference, and then we'll end. The judge said that, the court said that in the instant case, the applicant herein at all material times denies the allegations made against him. It was therefore incumbent on the respondent, that is Shraj, to give the applicant the right to face his accusers as outlined in its regulations. There is no dispute that before coming out with their decisions, the Shraj interviewed certain people. Those interviews, in my opinion, assisted Shraj to arrive at their decision as contained in a certain exhibit. That's their decision. In this light, Ejenim Boateng should have been afforded the right to cross-examine those witnesses to ascertain the veracity of the information given to Shraj, which formed the basis of its ruling. Failure to give Ejenim Boateng the chance to cross-examine the witnesses is therefore a breach of the principle of natural justice, particularly the auditorum patem rule. On the foregoing, the judge held that the decision of Shraj in respect of the petition or the complaint by Ghana Integrity Initiative had been quashed, so it had been thrown away because they breached his right. Now, what you don't hear about is this other judgment, which is dated the 21st day of January 2022, also in the High Court by Her Ladyship Justice Elfreda Ami Denchi. And in this one, the same arguments were made, but the court held that Shraj was an investigative body and that he was not denied the opportunity, a fair hearing. And that as an investigative body, Shraj can call people and speak to them, and you don't need to have the opportunity to cross-examine them, so to speak. So two decisions of the court, contrasting, if you like. In that case, the judge ended by saying, analyzing the facts of the case and applying the relevant laws and cases stated, this court is of the opinion that there has been no breach of natural justice and certiorari does not arise. The application for certiorari is hereby dismissed. So, this matter was appealed in the Court of Appeal, and the Court of Appeal once again upheld this High Court judge's decision. So, as we understand, it is the case that Shraj intends to appeal this new High Court decision in the Court of Appeal and hoping that it will overturn that one as well. So what is going on? It's interesting. I just end my take on this note, just to give you the two different pictures. And this was a matter in which, when the investigations had been done, a man who is now seeking to become president of the country gave his platform to the PPA boss who had been sacked to vilify the journalists and have a journalist sitting on that platform claiming to be journalists, also vilifying the journalist in the face of all the evidence. That will be my take. Corruption is not easy to fight. We'll be right back to deal with the vexed matters that we are canvassing for you this morning.